is to hold an interview with Attorney Elephant.
Elephant.
Yeah, Elephant. Okay, all right. Just want to make sure I say it correctly. So, and in order to do that, we need to call her. So do we need to dial 8 or 9 to get out?
Not likely.
No.
I know someone who can ask, but you don't have his number.
No,
Just try dialing.
yeah,
Okay.
I think 1 is fine.
Where is he?
I didn't set this up.
Yep, that's all right.
I would just go 1.
Just try dialing.
1. Yep.
Number.
Did you get a dial tone?
Interesting, right? Somebody will sound it.
Nope, don't think it worked.
Usually open the line.
There you go.
Yeah, okay, some do it another way. All right. So,
Your call cannot be completed as dialed.
I'm gonna try and then I.
Sounds like a video games, like Pong or something.
here we go. Is this loud enough?
Hello.
Hello, this is Tim Tenhay from the Merrimack Conservation Commission.
Hi, how are you?
Great, how you doing?
Good.
Can you hear me okay?
Yes, yes.
Great. So as we all we're all in a room staring at each other saying, what do we say next?
Okay, so wait just a second. I'm going to get out of the, got some background noise here. Sorry. Okay, so, all right, well, hi, it's good to talk to all of you.
Hi.
Can you hear some people in the background?
Yeah, I hear some people. I mean,
Okay, yeah.
yeah, I can hear.
Okay, good. So we're kind of going through a two-part process tonight. I think you're aware what we wanted to do is, since we're a public body here in New Hampshire, we need to hold this part of the interview process just to make sure we're all good with things as an open discussion. And this is being recorded. In fact, it's just so you're aware. And it will be available over our closed cable system as well as over the internet streaming video later on this week. So in case you want to refer back to this part of the meeting, you'll actually have the opportunity to do that if you'd like it at any time of day or night.
Oh, okay, that's kind of cool.
Yeah. And believe me, people do watch these things really late at night sometimes.
Yes.
So really what we're aiming to do with this first part is just to make sure that we as a commission and you as an attorney are comfortable with us having a formal relationship, and when we're all done, we'll potentially hold a vote in order to solidify that, and then after that, we'll switch off and turn off the video and have a consultation with you, assuming that the vote goes in that direction. So,
Okay.
right? So.
Okay.
So, when we first saw your fee schedule and information that you exchanged with Cindy, this was before the actual filing that Kinder Morgan had done. But now that we're past that point, and in fact, I'm not sure if you're aware, we've actually filed as interveners in the process. Good. So we never heard officially back from FERC that we are interveners. I'm not sure they're notifying anyone.
No, they don't have to. If it's unopposed after 15 days, it's granted automatically by operation of law, so you won't get anything formally, but you can consider yourself an intervener. I doubt. I haven't seen Kinder Morgan opposing anybody's timely intervention. So.
Okay. Yeah, and I don't recall seeing anything either. So I assume that we were interveners at this point. So.
Mm-hmm. Okay.
So really the questions that I have, and I think many of us have, is how does this relationship work with you being, a few hundred miles away from us? And especially,
Okay.
Yeah, so what are your thoughts on that?
Well, I do work with clients all over the country. I'm not involved in every pipeline proceeding, of course, but because I do work on pipelines in Ferguson, D.C., I am accustomed to working with clients in other locations. And I think really the relationship depends on how active or not an organization wants to be in a proceeding. Many times, with some of my clients, they will just want to be involved at a couple of different junctures at the intervention stage, when the environmental documentation comes out, and then rehearing. And so we basically will discuss, when those junctures arise, we'll discuss them by phone, and then either, I'll send a scope of work and give them an estimate of what the cost would be for that phase, or maybe, we have something in place that's been pre-agreed. So we usually can just do most of what we need to by phone and email. Sometimes I will go up to visit a site. Sometimes it's helpful to me, depending on the type of project, to actually see where it's going to be located. And so in a situation like that, I might go up and then meet with the client while I'm on the site. And then, there are occasions, too, when my clients will sometimes come to D.C. because they have decided to meet with somebody on the commission or somebody in Congress, and, I might meet with them there. But, most of this work, even with my local clients, honestly, most of the time we work by phone and email anyway. So, I don't have people in my office all the time when something is due.
Okay, so can we do email and still have attorney-client privilege?
Yeah. Oh, yes. So, yes. There are a couple of different ways depending on the level of privilege that people want. Usually, I don't necessarily put secret strategies into emails. A lot of times, the emails are just sort of like, here's the rehearing request, let's discuss it. But there are times, and my emails, the standard practice in my office is to denote that the emails are privileged and confidential. And for people who want, an added level of confidentiality, I have, other sorts of portals where you can log in and, upload and download documents. I can do things that way too if there are clients who are, extremely concerned about passing confidential documents by email. But I found that the level of security that I have on email, combined with privileged information, and also caution to clients to not, forward the emails to other people, those types of things, usually tends to adequately preserve the privilege.
Yeah. Okay. That's good. So I don't monopolize. Anyone have any questions?
No.
Following along. So
I had a question. Do you have any other clients in southern New Hampshire currently right now?
So I am representing the town of Mason, and I don't represent any individual landowners, but I have spoken with some individual landowners about there are some resources that I have that are specific to landowners, more residential homeowners who are impacted by pipelines. Just some information like that I sometimes will provide to people, and then maybe have a consultation with. But I don't represent any individual landowners, just the town of Mason.
okay.
And I represent the Franklin County, what is Franklin? Oh, I'm trying to remember the acronym. Franklin Regional Council of Government, and that representation is really more almost like a consultation relationship, because it's a county. The group is a resource. They provide resources to a number of a number of municipalities within Franklin County. So I advise the FRCOG, which is the organization, and they take the advice that I provide them with, and they pass it on to the counties, or they will actually do the filings on their own. So their filings in the commission docket are under their name, but in disclosure, I have reviewed some of those documents or provided them with information, but I consider this to be more like a consultation type of arrangement rather than a representation type of arrangement.
How about other conservation commissions? Any along the road, not necessarily in New Hampshire, but any of the other impacted states?
Not in. I'm not working with any in this case, or actually, not in the Kinder Morgan case. I have represented. I represented a conservation trust and also wasn't really a conservation trust. It was a family that was holding property in trust for purposes of preservation. So I'm familiar with the issues, some of the issues that are faced, but I don't represent any others in the NED proceeding.
Okay, thank you.
Mm-hmm.
So as I understand things, the next thing in the process, that was Jody, by the way. I think you've got a listing of all the members. So, my understanding is the next thing that we're kind of anticipating is for FERC to come back with a draft environmental impact study.
Yes, so that is sort of the next action that FERC will take. Well, I guess before that, FERC will also send out requests for additional information.
Right,
They'll send those to the company, and I think I saw some of those have issued already. I don't know when you filed your motion to intervene whether you filed comments along with it or the level of detail that you provided. I think that it's usually important before FERC issues the draft environmental impact statement for entities to have some sorts of more extensive comments on the application on the record, because the thing is that once FERC issues, many people think quite logically, because this is how it's supposed to work, they think that when the agency issues the draft environmental impact statement that they can go and file comments and identify the deficiencies and ask FERC to make corrections or changes. But unfortunately, the way the process seems to work at the Commission is that if you don't raise an issue before the draft environmental impact statement comes out, it will not be considered. And if you raise it afterwards, it'll just be ignored or rationalized away, or the Commission will say, oh, you should have told us sooner that, that if we went this way, there would, we'd hit wetlands. It's too late for us to do anything now. So, so if there are issues that are somewhat critical that you have not really, that doesn't appear to you that FERC has paid attention to, through the information requests or anything like that, or if you haven't included them in your motion to intervene, which you may have, those are the kinds of things you really want to bring to their attention before the draft comes out. And then, once the draft comes out, of course, that opens up an opportunity to comment, and that's a very important part of the process too, because if you don't file comments, then if you try to raise those issues later on, you'll have lost the opportunity. So you're really going through like a funnel, and the further down the road the process gets, the opportunities for being able to raise issues and get responses becomes, it narrows. So,
okay.
Yeah.
That's very interesting what you just said, because
And certainly not encouraging.
so we did provide some comments with our intervener.
Okay, great.
But we mostly commented during the scoping period itself.
Okay. Well, I would actually, if you commented during the scoping period, I would almost just even refile those comments just to, make absolutely sure they're being considered here, because they were filed in another docket, and I don't know whether the applicant actually, accommodated you on any of those. But
No.
if they didn't, oh, okay. Well, then I think it would be worthwhile to just, if you've done the work already, just refile them just to make absolutely sure they're in this docket. I don't know exactly how things work internally at FERC, but I don't know if all of the same people who work on the pre-filing, are the same ones who work on the application itself.
Okay.
So just to make it easy for them so that they don't have to dig through their piles of stuff, even, refiling the scoping comments and saying, look, we filed these before, nobody responded. We'd like to, get a response from the applicant on these issues, or have these issues addressed, or make sure they're part of the record.
Yeah, what makes things hard with the current route through our town is that there's a number of alternatives, and it's been very unclear to us until the very recently which one is the preferred route. And so we kind of held off putting out comments against all the alternatives because we weren't sure we wanted to put that much energy into it. So.
Sure. No, you're absolutely right. It's definitely a deficiency, and that route is a moving target.
Yeah. Okay. So when it comes time to do the after the draft comes out and we have the opportunity to comment, is that an area where you could play a role and provide a review of your own, looking at things that we might not normally consider or see?
Yes. So what I typically do, I feel, that as an attorney, the value that I bring to the comment process is, first, I help to identify any legal deficiencies that may be present in the environmental impact statement, really to preserve them for appeal because they are almost never changed, during the process, although you never know. So that's the first thing, is to identify legal deficiencies or potential situations where FERC perhaps has, violated the law. I don't mean it there's situations where, for example, they have to wait until water quality certificate issues, and sometimes in the environmental review they'll suggest that they're going to go ahead and, issue a certificate before that happens. I also address, in the comments on the environmental impact statement, also will tend to address, some of the other issues, like whether the statement is consistent with, there are various FERC regulations and guidelines that pertain to mitigation and remediation, and even though, honestly, they're not that robust, sometimes they still, the EIS even falls short on those grounds. So those are the kinds of things that I can usually identify and help with commenting on. I mean, certainly on issues like, the impacts to your properties and the lands that you're holding, that would be something that you would be much more adept at identifying, but it's also possible I might be able to help, back up your factual position with a legal argument as well.
I see. Okay. All right. So when we reach that point, is that something that you'd prefer to scope with us and then come back with a bid, or however you want to call it?
Yeah, that is the type of thing where, at the time, I mean, first of all, take a look at how big the environmental impact statement is. One of the things is that, because I do represent two other clients, I mean, if there happen to be some issues that are common, so that I'd be reading one section and it would apply to everybody, I mean, that would be the kind of thing where I could sort of, allocate the costs rather than, billing everybody, for 3 hours of time to read section 1. A lot of the issues are going to be very different. The impacts to your property, to your conservation lands are going to be discussed probably in a section that's different from some of the others. But, and so based on that, and the size of the environmental impact statement, I can probably, it would be easier for me to give you an estimate at that time.
Okay. Now, we are limited in days to respond, correct?
Yes, there is, they will usually give between 30 and 45 days. And when the notice issues that the draft environmental statement is going to be released, it'll have a deadline in it.
Okay. All right. So, well, I guess what I was getting at is this: once we, know that that's going to happen, we probably want to act fairly quickly then.
Yes, yes. FERC is definitely starting to crack down on late commenters, and it used to be that if you were a couple of days late in commenting, they would still respond to your comments, but they don't do that anymore. So,
okay.
Yeah.
Because where we are a public body and we meet periodically, we may have to then have a special meeting in order to facilitate moving this forward then, I guess. So.
Oh, I see. Yeah. Well, I think I haven't looked at the schedule recently. Usually FERC will issue a schedule to sort of give at least a rough idea of when a draft environmental impact statement is going to issue. So, it might not adhere to that schedule, but it at least it would give you a little bit of information for planning purposes.
Okay. All right. So let me fast forward a little bit then. So assuming FERC decides that it meets the public need and they go to issue a certificate, if I said it properly, then...
Mm-hmm. Yeah, that's right.
Then if we would probably want to have you then take a look at that and see if there's opportunities for us to appeal, or I'm not sure the exact right name for it is. So.
Right. It's the first step would be to file a rehearing request at FERC, and so that would be something I could help you evaluate. The rehearing process is really, FERC has changed it a little bit, so really it's more of a, it used to be you could file a rehearing request and FERC might sometimes change its position, and in fact, even with the conservation property I represented on another pipeline, FERC actually did change its position a little bit, teeny tiny bit, but otherwise you're really looking at the rehearing in most cases to just preserve issues for going to court. But I could help you assess the likelihood of success and help you evaluate whether it's something worth moving forward with when it gets to that point.
Yeah.
But I still think you're somewhat relatively, I would say you're at least 6 to 8 months down the line from a certificate issuing, notwithstanding what the applicant has said, their own schedule is. It's just based on my experience, what my guess would be.
Okay. All right. Now, so would the rehearing itself be done just through submittals, or would they actually do something at their office?
No, a rehearing request is filed 30 days after the certificate issues, and it's basically something, again, that's just on the papers. It's a document that is somewhat specific in structure. You have to sort of list the issues up front and then, address the arguments, but it's all done electronically, just like all of the other submittals that you have done.
All right. So then the last set of questions I have are really about, so if this thing does move forward and rehearing doesn't, give us the relief we're looking for, and it comes down to Kinder Morgan starting to actually wanting to seek easements and things like that, is that mostly our easements or even eminent domain? Is that mostly a state-dictated activity, and where you or someone or an attorney here in the state of New Hampshire would have to file for us?
So with eminent domain, if it actually becomes contentious and they file a suit against you, my experience has been they have the option of going to federal court or state court to actually initiate an eminent domain action. My experience generally, I would say the majority of pipelines go to federal court just because the process is a little bit more favorable to a corporation than a local court, a state court. And so I have practiced in federal courts in different parts of the country, either with local counsel or somebody moves me in pro hoc vici. And then if it's something that's filed in state court, I sometimes will stay on to sort of consult or advise the local attorney with issues specific to FERC, but I'm not really as comfortable practicing in state courts just because especially for eminent domain proceedings, the procedural issues are so different that it's probably not efficient, and it's just something that I could really screw up for you. So, so that would be the kind of thing where you would want to be local. In terms of negotiating easements, I've helped clients negotiate easement agreements in different states. Sometimes I will, consult with a local attorney to see if there are any, issues that are unique to actually, filing it, or if there's a certain format it has to be in. But the value that I bring to working with parties on the easements is there are certain things that a company can or can't do. The company's rights to eminent domain are bounded and defined by the FERC certificate, and so there are certain things in the FERC certificate that the company won't be able to do, like put in 2 pipelines or expand the size. I mean, it can always do that in the future, but it would have to go back and pay you more. So, like when a company negotiates for an easement, they always want to get the rights up front to put in 2 pipelines, and then, if they come back 5 years later and put in the second, they'll say, oh, we don't have to pay you now because we already paid you the first time. So there are those kinds of things that, issues that I can identify because I'm familiar with the types of things that come up in a FERC easement process. Also things like remediation. I know that many times it takes these companies a very long time to remediate or mitigate or even clean up the site. And there are things that you want to put into an easement agreement to protect yourself in those situations.
Okay. All right. Does anyone else have any questions?
No, you got it.
So, all right, so I guess going forward from here, I think really what we're looking to do in the short term then is to be able to consult with you until we get close enough to a draft EIS, and where we would then potentially on that have a very particular arrangement with you. Does that sound right?
Right.
Yeah. Okay. Everyone agree with that?
Mm-hmm.
So, okay. So how does everyone want to move forward, or what do you want to do? Mm-hmm.
Make a motion that we,
So Carolyn, so we're going to do a little bit of official activity here so we can move this thing along, unless there's any other comments you want to add before we do that.
No, I don't have anything to add at this point.
Okay.
I make a motion that we hire Carolyn Elephant to represent the Merrimack Conservation Commission in our legal proceedings for the pipeline.
Okay, with funds coming from Fund
With funds coming from Fund 53.
53, yeah.
Second.
All right, so that was moved by Cindy and seconded by Gage. Is there any discussion on the motion? Seeing none, I'll call a vote. So all those in favor signify by saying aye.
Aye.
Aye. Opposed, abstentions, that passes 7-0-0. All right. So you're hired. How's that, Carolyn?
Oh, that sounds great.
All right. So what I want to do is take about 10 minutes to close down this portion of the meeting, and then we can continue our discussion. Do you want to slip away? You want us to call you back? How would you like to do that?
Yeah, if you could just maybe call back in 10 minutes. I just have one quick thing I need to to finish up. And your call had come in a little bit late, so I just want to make sure I get it done before 7:30. So I'll be available in 10 minutes if you want to call back then.
So we'll call you at 7:20 then, right? Did I get that right?
Yes.
Okay.
That's right.
Great.
Okay, great.
Great.
Okay,
Good.
thanks.
All right. Thank you.
Okay.
Thank you.
All right,
you.
bye.
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 Fix that clock.
Yeah. All right. So that was all we have on this agenda item. True. All right. So public comment. No one from the public. Commissioner comments. Gina, Jody, Mike,
Nope.
Cindy, Matt.
you to Cindy for doing the legwork and finding. Oh, yeah. Thank you to Cindy for doing the legwork and finding our attorney for us.
Yeah, thank you. Yeah. Gage?
Thank you, Cindy.
So I'm all set.
Motion
Like
to
to
adjourn.
Second.
All right, so moved by Cindy. Yeah, go ahead.
Do you want to have a moment of silence
I do. You're right. Thank you.
before we adjourn?
All right. So, unfortunately, over the weekend, we lost a native of Merrimack to a very unfortunate incident, and it's quite appropriate, I think, for the commission to take a moment and extend our deepest thoughts and prayers to the Goyden family. Yeah. Okay. And so let's do that for a moment. Thanks. All right then. I mispronounced her name, didn't I?
I'm not sure on it either, so I think it's Gendron.
Jen, yeah?
Yeah.
Okay. All right. Okay. So moving forward, so motion to adjourn from Cindy, seconded by Matt. All those in favor signify by saying aye.
Aye.
That passes 7-0-0 at 7:12 p.m. and we started the meeting at 6:40 p.m. All right then.
Yeah. We're going to time you, Matt. No.
So I'm assuming you all have some more questions, or you want to go a little bit deeper with any of this?
Never hired an attorney before, so.
Yeah.
Yeah, me either.
Yeah.
We got a lot of good information already.
Well, I think that was the scoping comments. Okay, so we need to refile those. Because,
So-
I thought our scoping comments were pretty in-depth and.
Yeah.
Right, I was under the impression, because I thought we had talked about this, is that the agenda or the docket changes once the filing period ends. It becomes a new docket, and we had to refile all of the questions if they weren't answered to get them on the second docket, because they don't just carry over.
Oh, they don't?
No, that's what I thought we learned that here. So I was under the impression that it becomes a new docket, you got to refile everything.
It's not been